101. I'm Rodney Rouzan, and today we're going to go right into my case. I've already served the request for admissions, and the city failed to answer them properly. Okay. This video is a full overview of those admissions, what they were supposed to respond to and what they refused to answer, and how that put us in a position to have every single one deemed admitted. This is important because the admissions are facts. Once they're admitted, the defense has nowhere to go. The record becomes locked in.
This is Word Wars 101.
Welcome to a deep dive into the, let's call it the uncompromising world of legal warfare, where victory isn't about emotion. It's about the cold, hard facts of dates, signatures, and just following the rules.
And today we are tracking a battle that spans years. It starts with what's alleged to be fraudulent documents used by a major city, and it ends. Well, it ends with a complete and mandatory collapse of their legal defense.
We're focusing on a case brought by Public Safety Officer Rodney Rouzan against the city of Los Angeles. And, we're really just tracking the documents he filed.
And here's a detail that's just, it's fascinating. The plaintiff, after being represented earlier, is now fighting this entire case on his own, in pro per.
That is such a crucial piece of this, the decision to go up against a massive city legal department all by yourself. It really sets the stage.
It does. So the documents we're digging into today are the 2022 whistleblower complaint and a 2025 motion to deem requests for admission admitted.
And together they show how meticulous, just obsessive documentation can become a weapon powerful enough to just dismantle a well-funded defense.
So the mission today is to really get how the city's initial alleged misconduct, I'm talking about these unadopted COVID-19 forms, how that created a weak spot.
A weak spot that the plaintiff then brilliantly exploited years later, using the rules of discovery to basically force the city to admit the truth.
Or at least face the consequences of not being able to deny it under oath.
Exactly. This case is, it's a masterclass. It proves that a system built on, shortcuts and hiding things, it just can't hold up under real legal pressure. If you can't verify your own documents, your entire house of cards just collapses.
Okay, let's do it. Let's unpack the initial trigger. We have to go back to 2022.
Right.
The city tries to place the officer off duty, and their reason was, quote, non-compliance with mandatory weekly COVID testing.
The first shot fired, really, was a memo. It's dated June 3, 2022, from HR Director Minerva Gutierrez.
And what does it say?
The memo basically paints the officer as a compliance risk. It specifically claims there were 9 prior attempts to tell him about the mandatory testing and that he allegedly failed to meet the requirements. The threat was clear: comply or you're out.
Okay, and this is where individual record keeping just becomes a superpower. I think most people, you get a letter like that from HR, you panic, you fold.
Right. But this officer, he had the receipts. He didn't just deny it, he immediately pushed back with his own records he had been keeping himself the whole time.
So he didn't just say, nuh-uh, he provided proof.
Hard evidence. The source material shows a list of 16 specific COVID test dates, complete with unique testing numbers for each one. It spans from late 2021 all the way to June 2022.
So it proved, without a doubt, he was testing. He was compliant with the actual rule.
Absolutely.
Yeah.
So the city's whole reason for this disciplinary action non-compliance, it was just factually wrong. It was completely refuted by the employee's own paper trail.
And that completely shifts the focus, right? It's no longer about the employee's actions. It becomes about the legal basis for the city's mandate itself.
Precisely. Once he proved he was complying, the officer then zeroed in on the documents the city was using to enforce these rules in the first place.
The whistleblower complaint alleged that the HR director, Gutierrez, she presented 2 documents. Something about exemptions and policies that just weren't official.
And he didn't just allege it, he set out to prove it. He got a fellow officer, David Rogers, to actually go meet with the city clerk's office, the official keeper of city records,
To see if the forms were legit.
And the answer came back fast. The city clerk's office couldn't find them. And to nail it down, on July 8, 2022, they sent an official reply to a public records request. It confirmed, and I'm quoting here, they were not in possession of any documents or information relating to your request.
Wow. Okay, so let's break that down for everyone listening. It's like a bank trying to foreclose on your house with a contract.
Yeah.
And when you go to the county recorder's office, the only place that officially stores that kind of document, they just say, sorry, we've never seen this. It doesn't exist in our records.
That's a perfect analogy. The city's entire legal standing for this action just evaporated. The forms they were using to threaten his job were unofficial, unauthorized, and never properly adopted.
They were allegedly enforcing an illegal policy.
Yes, and exposing that, that whistleblowing action. That's what led directly to the retaliation.
Let's connect those dots. The timeline is critical here.
Okay, so the first EEO complaint, it alleges unlawful action and violations of POBAR. That's the Public Safety Officer's Procedural Bill of Rights. That was filed August 11th, 2022.
And POBAR is a big deal. It gives officers specific procedural rights during investigations.
Huge deal. Then, just 2 weeks later, August 25th, he makes another disclosure. This time to a special investigator, again saying the airport was acting unlawfully, using these bogus forms and violating his rights.
And how did the city respond to him engaging in these legally protected activities?
Well, years later, in a request for admission number 19 specifically, they admitted that they did discharge him.
So they admit the firing. That's half the battle in a retaliation case right there.
Yeah.
You have the protected activity and you have the adverse action.
Exactly. But then they did the standard legal two-step. They admitted the what, but denied the why.
They denied the one thing caused the other.
Right. They denied RFA 20, which flat out asked them to admit that his August 25 disclosure was a contributing factor in firing him. They denied RFA 22, which said the same thing about the August 11 EEO complaint.
And what about the forms? Did they ever look into them?
Well, RFA 25 asked them to admit that they conducted no investigation into the unauthorized forms, and they denied that too.
So their official story on paper is, yes, we fired him, but it had absolutely nothing to do with him exposing our use of fraudulent policies.
And that denial, that's the story they have to stick to. That's the story someone has to swear to under oath. And this is where their strategy just smacks right into a procedural brick wall a few years later.
Okay, this brings us to the discovery collapse of 2025. I mean, this is where the paper trail itself becomes the executioner.
It really does.
This part gets really interesting, especially for anyone listening who follows how big institutions handle lawsuits. Fast forward to 2025. Those GRAC requests for admission, those critical questions, are served. The city has to respond truthfully, and most importantly, under a very specific legal procedure.
And this is the mandatory verification requirement. It's not optional.
Right.
When you respond to RFAs in California, you can't just send a memo back. The response has to be sworn under penalty of perjury. And the person signing has to either have personal firsthand knowledge of the facts, or they have to have conducted a diligent, reasonable inquiry before signing.
It's like signing your tax return. You're swearing it's true.
And that carries immense legal weight. But the city, when faced with this test, they immediately failed. The responses were late, for one thing, but more importantly, they were legally void from the start.
Because of the verification. The first red flag was what the plaintiff calls the dummy signer issue.
The city attaches a verification signed by Vivian Howell. She's the Director of Risk and Insurance Management. Now think about that title. Is that the person who knows the day-to-day facts of an HR dispute from 3 years ago?
Probably not. Her job is managing financial risk, not police discipline.
And her own sworn statement confirms it. Her verification literally says she lacks personal knowledge because the matters were and I quote, composite of the information of many individuals.
But she didn't even claim to have done the other part, the reasonable inquiry.
She did not. And you have to see the strategy here. The city has spent years denying everything, denying the forms were fake, denying they retaliated. But when it's finally time to put a witness on the line to swear to those denials,
They can't find one.
they can't find anyone directly involved, not the HR director, not a police chief, no one willing to put their name and career on a statement under penalty of perjury swearing to those facts.
So they use the Director of Risk Management as a placeholder? I mean, it just screams that the organization has no confidence in its own story.
It's a procedural check-the-box exercise without any factual substance behind it. And it got worse. That initial verification was also chronologically impossible.
What do you mean?
The final responses were served on November 3rd, 2025. But the verification from Mrs. Howell was predated to October 31st, 3 days before the responses were even served.
You can't swear to the contents of a document that hasn't been finalized yet.
You can't. That defect alone makes the whole thing legally void, a non-response.
And the plaintiff, who at this point is acting as his own attorney, he catches this.
He catches it, points it out, and the city scrambles to fix it. And their attempt to cure the problem leads to an even more astounding blunder.
This is where it just defies logic.
It really is the moment where the rules of time and space seem to bend under legal pressure. The defense lawyer emails what he calls amended verifications. It's late at night. 8:53 p.m. on November 24th.
Okay, so they're trying to replace the bad forms with good ones.
But the new documents, the ones attached to that 8:53 p.m. email on a Monday night, were both dated as having been executed on the 25th day of November 2025.
Wait, they were dated for the next day? For Tuesday?
Yes. You don't need a law degree for this one. You cannot physically send a document at night that was signed and sworn to under oath tomorrow.
It's a chronological impossibility.
And the law is very clear the execution date has to be truthful. To send a document that claims it was signed tomorrow is itself a violation of the oath.
And the plaintiff's motion just lays this all out, right? With the city's own timestamps as evidence against them.
Meticulously. So because of the predating, the lack of knowledge, and then this final impossible timeline, the city, legally speaking, served no valid verified response at all.
So what does that mean? What's the consequence for this pileup of errors?
This isn't a slap on the wrist. This triggers one of the most powerful and, more importantly, mandatory sanctions in California discovery law.
Mandatory, not discretionary. So the judge doesn't have a choice here.
The judge has no choice. The rule says if a valid, verified response is not served, the court shall deem the requests for admission admitted, period. The unverified responses are treated as if they never responded at all. It is a legal hammer.
So all of the plaintiff's allegations, his version of the facts in those RFAs,
they automatically transform from claims that have to be proven into facts that are legally admitted by the city.
this is lethal. It just guts their entire defense.
Absolutely. They now risk admitting everything. Number one, they admit RFAs 1 and 2 are true, that the COVID forms were unadopted, unauthorized, and unofficial, which confirms the whole basis of the whistleblower complaint.
And even more critically, they admit the reason for the retaliation.
Correct. They would admit RFA 20 and 22, that the discharge was directly caused by his whistleblowing on August 25th and his EEO complaint on August 11th.
If that's admitted, their whole pretext defense that they fired him for some other reason is gone.
It's gone. They also admit that their conduct was a substantial factor in causing his harm, which is RFA 24. Strategically, the fight is over before it even begins.
Because they couldn't produce a single credible signature.
And that failure, which is rooted in their lack of a factual defense, results in them admitting to the core claims of fraud and retaliation. And, of course, there are mandatory monetary sanctions.
The court has to impose them.
Has to. The plaintiff requested $22.50, which is just 15 hours of his time at a pretty modest rate, just for the work of documenting the city's complete procedural meltdown.
The deeper read here, really, is that the city knew its case was weak. They knew the forms were bogus, they knew the retaliation was obvious, and they could not find a single employee with real knowledge who was willing to risk their career by swearing that the city's story was true.
The director of risk management was the designated fall guy because the facts wouldn't support anyone else. The document trail started with alleged fraud in 2022, and it ended with procedural misconduct in 2025. This entire legal victory is built on the plaintiff's persistence and his detailed attention to the rulebook, all while representing himself.
Just let that sink in for a moment.
Yeah.
This whole journey starts with one officer who was just meticulous about keeping his own records, his COVID test records. He used that simple list to expose a fraudulent policy.
And that created a pressure point, a single point of weakness in the city's armor.
And that pressure point, 3 years later, leads directly to this huge legal victory. Why? Because the city couldn't find a single person to stand behind their claims under oath.
And it all came crashing down because of a series of void, defective, and chronologically impossible documents. The documents themselves, in the end, forced the city to admit what the whistleblower was saying all along.
It's just a powerful example of why legal process matters. It exists to stop big organizations from just inventing convenient fictions to justify their actions.
Due process is enforced by these technical rules, even tiny details like signature dates and witness knowledge.
The entire path from one EEO complaint in 2022 to mandatory admissions in court in 2025, it all hinges on the power of the paper trail. Corruption exposed by documents, and a defense defeated by its own defective paperwork.
It's a legal checkmate.
A final thought for you to consider. Given that the Director of Risk and Insurance Management, Vivian Howell, was the designated dummy signer, the one who admitted she didn't have personal knowledge, what does that tell you about the city's own internal assessment of its liability? When the person whose job is literally to manage risk won't vouch for the truth, you have to assume the risk has already become a reality.
And just to build on that, In what other areas of city government, think about building codes, environmental rules, any other disciplinary action, where might the absence of a proper paper trail or the inability to find one credible person to sign their name expose a public agency to this kind of immediate mandatory legal defeat? The system's emphasis on transparency and sworn testimony, it leaves zero room for manufactured timelines or witnesses who just don't know the facts.
Now that you've seen the admissions overview, stay tuned for the next video. That's where I use the admissions once they're deemed admitted and show you how they become the foundation for the next phase of this case. This is how we move from state court into federal court using their admissions against them. Follow along because this is the turning point. Like and subscribe, and I'll see you in the next video. Thank you.
Words in papers, words in books, words on TV, words for books, words of comfort, words of ease, words to make the fighting cease. Eat your words, but don't go hungry. Words have always nearly hung me. Words are stupid, words are fun. Words can put you on the run. Concrete words, abstract words, words to tell you what to do. Words can put you on the run.